Mr. Chairman, we are live.
Thank you. Someone want to grab that back door? The lawyer in me doesn't like open doors, ever. All right. Well, welcome to the March 8th day of the Judiciary Committee. We have a healthy agenda today. Kind of glad I put so many bills on the agenda because then I was able to fill up the room with all these bright, smiling eyes. Okay, so with that being said, though, I have a lot of bills on the agenda today, but I also have a goal of getting through all of these bills today. Because the days after today, the days in the legislature, at least on the House side, I know, are going to shorten in the morning and shorten in the afternoon as time goes on from here and we enter the budget week. And so all of that being said, that's my goal is to get us ahead because more bills will be coming. So keep that in mind. I say that to the members. I say that to the public. Keep that in mind so we can try to move judiciously today. Okay, will you please call the roll?
Yes. Representative Crago.
Here.
Representative Larson.
Excused.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Williams.
Here.
Vice Chairman Washut.
Here.
Representative Yin.
Excused.
Representative Zwanitzer.
Excused.
Chairman Olson.
Here.
Mr. Chairman, we have 3 excused and 6 present.
Thank you, Kay. All right, we'll begin with House Bill 246. Representative Stivar, welcome to the Judiciary Committee.
Thank you, Chairman.
Representative Provenza, you may sit wherever you would like. Is this like a bait and switch? Okay. All right.
Thank you, Mr. Chairman, Representative Stiver. House Bill 246 eliminate fines and fees for juvenile offenders. And I'm going to turn the explanation over the bill to Representative Provenza.
All right. Representative Provenza, please
Mr.
introduce this
Chairman.
bill to us.
Thank you for allowing our dynamic duo to be here today.
This is an unusual duo, but yet a good duo.
Yeah. House Bill 246 is eliminating fines and fees for juveniles. As the title says, juveniles in the state of Wyoming, when they are involved in the juvenile justice system or the criminal system, end up having to pay, or their parents end up having to pay for fines and fees. So currently statute would say that parents are required to pay for their appointed counsel. So even public defender costs. They are also required to pay the state child support for youth placed out of their home, including placements for detention or treatment, and also fines and other court or probation fees incidental to disposition or sentencing of a youth. So there's, I can walk you through the bill if you'd like, committee, but really this bill is at its face value doing what it's supposed to do. And you did receive quite a bit of information, I believe, over the weekend from folks who are really invested in this and are much more educated on the topic than I am. In the bill, we see that on pages 2 and 3, we have amends Wyoming statute 76106 B and C. This just eliminates the requirement that courts determine a parent or guardian's ability to pay for legal representation and removes the requirement that the court order reimbursement. Then when you get to line 22 of page 3, going over onto page 4, we see this amends 14-6-201 subsection A and 9. This eliminates the contempt of court from the definition of a delinquent act, which prevents the use of using contempt of court to authorize incarceration of a youth for probation violations or for status offenses.
Is that Representative Forenza? Was that for status offenses or non-status offenses?
Sorry, I believe, yeah, I have status offenses, but I think it means non-status offenses.
So my question would be so one of the fines I understand we're eliminating would be the fine of a minor in possession of tobacco. Is that correct?
I believe so.
And so if we eliminate that fine, but yet we can still issue a citation. And so then are we eliminating contempt of court for that individual as well? So we issue a citation, there's no fine and they don't show up. What's the consequence?
Excuse me, Mr. Chairman. I'm not entirely, I guess I might have to make sure I get clarification before I speak and don't tell you what's not true. But the goal is so that we're not putting juveniles back into the system in detention or punishing them specifically for failure to pay on fines and fees. For the tobacco citation, I'll just be honest, off the top of my head, I don't know right now. And hopefully we'll be able to answer that question if that's.
Representative Oakley, you have an answer to my question?
Thank you, Mr. Chair, and Representative Venza and Representative Stibar. It's certainly a good point. I mean, I agree. So usually if any defendant fails to appear in court, then a warrant can issue for their arrest, because if not, yes, it can languish on dockets. But I guess, but as far as using this for an example, that doesn't give me too much heartburn. Now, I'm not a judge. A judge might disagree, but because I don't think it would be worth the time or money or effort or necessarily even be appropriate to be putting an arrest warrant out for 20. I mean, I think the bond amount is $25 on an offender using like chew or smoking. So the reality is that things like that actually do cost the system more if they were to arrest. It doesn't answer the question of what to do with the court docket, though. It would languish. So they would have to basically issue a citation.
Well, and Representative Oakley, my question is actually not so concerned with the court docket, but that if we have a program for tobacco cessation, which we do, how do we get that teen into the program if we can't get them into the court to require them to take the program? I'm not concerned about the fine. I don't know that does anything at all. What I'm concerned about is if you have, and take whatever addiction it may be, I'm just using this as one example, whatever addiction we have, at least my concern, and I think most would share this concern, the concern would be to get the minor into a program to address the addiction. And so if we can't hold their feet to the fire in order to get them just into the courtroom, how do we mandate, in this example, maybe the juvenile just doesn't show up, and so the judge just orders it and then issues the order, which is fine. But then when the juvenile says, I'm not going to go to the tobacco cessation counseling, then when they don't go, they can't be held in contempt of court. So that's why I'm asking if the contempt of court applies to all offenses.
Yeah, Mr. Chairman, thank you for that question. So just looking through my notes and what I have in language here, my understanding is that it's eliminating the fine for tobacco and eliminating the contempt for unpaid fines and fees. The court can still order community service. So they can say, or they can also order treatment for tobacco violations. So there are other things the court can do than any other law violation, not just on tobacco, but it's not removing the court's ability to try and impose on this and try and do something and intervene. It's just removing the ability for fines and fees.
Thank you. Please proceed.
So then, after that, we get on pages 4 and 5, where we have, we're amending 14.6203 subsection F. This is just looking to add a new subsection that directs that fines and fees should be, shall not be imposed upon youths or their families if the youth was under 18 years old at the time they committed a crime. On pages 5 and 6, where you see amending 14.6219 subsection A to eliminate the ability to make parents or guardians pay for mental and physical health evaluations or institutional commitments ordered by the court. So currently, we have that in statute. And then pages 6 and 7, where we're amending 14-6-222 here to eliminate mandatory fees assessed on parents or guardians for appointed counsel. And then on pages 7 and 8, you'll see that we're amending, so at the bottom of that on line 21 is the title, where we're amending 14-6-242 to attempt to exempt youth from contempt of court penalties of fines or detention. So being imposed into juvenile detention for violating, not paying those fines and fees. On 8 and 9, we amend 21-13-315 subsection F. And this is to eliminate the fee provision for court-ordered placement of children in detention, private residential treatment, group homes, and day treatment programs. Just a note that this section does not strike all the necessary language, and we might urge the committee to amend this page to strike the remainder of the paragraph that starts on line 5 after service through line 9 to strike and read the remainder of that paragraph. And then page 9, section 2. So this is your repeal. So what we're taking out entirely. 14.6-229 E3 and Romanet 4 is to eliminate fees for child support in cases where a child is placed away from home due to a delinquency adjudication. That repealed language, if you need it, I can read that to you. But that essentially that the parents or other legally obligated person must pay a reasonable sum for the support and treatment of the child. So child support essentially to the state. And then in Wyoming statute 14-6-235C, we are C and D. This is to eliminate additional language addressing fees for appointed counsel, guardians, ad litem, physical and mental examinations, witness expenses, services on process, and any other court costs, including any costs associated with placing a child on probation. So just removing those fines and fees there. And I have the repealed language if you so need it. Are there any questions so far? Sorry, just throwing statutes at you.
Yeah, after the repealer, you're just down to the effective date. Is that right?
What's that?
You're on the repealers, section 2.
Yeah, I just
all you
got,
have left is section 3, the effective date.
this act is effective immediately upon completion of all bill to become law. So I'll skip.
Perfect.
Yep.
Questions for Representative Stivar or Representative Provenza? You did such a good job. There's no questions. All right.
Good job.
Representative Provenza, if you, the only downside to doing such a good job on that presentation is that Representative Stivar is going to want to co-sponsor every bill with you now because he just gets to hang out.
As long as the work gets done.
All right, guys. Good job. Thank you. Public comment. Oh, sorry. I do, but my bigger concern was that I lost the record. The record's still going.
As far as I know, Carissa's still logged in.
All right.
It's still running.
Ms. Sheen, why don't you come on up to the mic and start your testimony?
Mr. Chairman,
Yeah, Clarissa.
I can hear you, but I cannot see you.
Oh, can you see me now?
There you go.
Yes.
Ah. Well, maybe we're ready to go then. Can you admit DFS, please?
Thank you. Thank you very much.
Make sure that we got everything else.
Mr. Chairman, they have been admitted to the meeting.
Thank you.
That's a good welcome.
Thank
All
you.
right.
Hold it.
Sorry for the technical difficulties, but we're back online. If you want to go ahead and introduce yourself for the record and then give us your testimony.
Good morning, Mr. Chairman. My name is Corin Schmidt. I'm the Director of the Department of Family Services. Also joining me today is Jill Kuchera, who is the Attorney General assigned to our agency. And I don't have any specific testimony, only to be made available for questions or comments about this bill if you should have any.
Oh, well, that's easy. Thank you, Cora. What about Jill? Do you have any specific testimony?
Mr. Chairman, no, I do not. Again, I'm available for questions, if any, from the committee.
Wow, great. And I have on my, Corin, I have on my list one more person from DFS who registered. Do we need to hear from Lindsay? Or is she
Yes.
also available in case we have questions?
Mr. Chairman, no, I can answer any questions on her behalf and we can chat on the side if there's anything that comes up.
Okay, all right. Then I feel good. All right. Well, committee, do you have questions for the Department of Family Services? Vice Chairman Washit.
Thank you, Mr. Chairman. My question is, I'm assuming if we are doing away with fines and we don't have authority to incarcerate under all circumstances, nor should we want to, that leaves us with, from my vantage point, community service as a sanction for these young offenders. How many of our counties have capacity for community service programs? And I guess I'll just leave it at that.
Mr. Chairman.
Please.
Representative Washit, so in terms of youth who are coming into the DFS system that are filed in juvenile court, which is different than maybe actions that happen in city court or county court, municipal court, or circuit court, DFS has the capacity for community service if they are on probation with us. The caveat is that not every youth that's subject to this legislation is involved with DFS youth or DFS. They may be involved with local probation or through local services like the community juvenile service boards. And I don't have the information about their capacity at the local level.
Thank you.
Further questions for the department? All right. Well, we thank you for being available for our questions. They may develop as time goes on. You're certainly welcome to hang out.
Thank you, Mr. Chairman.
Okay. Clarissa, on my list, that completes my virtual testimony on this bill. If there's anyone else that you know of out there, or if you're out there listening and you'd like to testify, please raise your hand. Clarissa, is there anyone else you have?
Mr. Chairman, Joseph Barron would like to testify.
All right, let's bring Mr. Barron in. And anyone else who's out there, just raise your little hand and we'll bring you in next. Mr. Barron, introduce yourself to the committee and then provide us with your comments.
Thank you. My name is Joseph Barron. I'm the Crook County and prosecuting attorney. I'm here in Sundance, Wyoming. I've been a prosecutor and the county attorney since 1990 in Crook County. And I am here to address the bill here, House Bill 246. Our association hasn't had time to basically go through this, nor have we been consulted about this particular bill and the ramifications of this particular bill. First off, what the committee did not, the sponsors did not tell you, and I'm going to tell you, is that how this actually works in practice, how the system works. So what happens is in a juvenile case where this is couched in terms of in the juvenile court system, the statutes are there, is the county attorney determines whether or not and where to file charges for a particular offense. And in most counties' cases, particularly in my county and other counties, the first thing that we do when any type of a juvenile offender comes up is we look and see what kind of case it is and whether or not we can run that child and their family to some degree through a diversion program. And in many cases, we have a diversion program, and other counties do too, where rather than filing a case, they can do things like community service, they can make restitution, they can take classes, things like that. In particular, say traffic offenses in our county is we have a program for first and second offense that you can do, the Alive at 25 program put on by the Wyoming Highway Patrol. And we also have an online traffic school for a second offense that can happen in that particular case. Other counties have these things as well. And so one of the things that happens with, quote, first-time offenders or somebody new to the system, they get, quote, second chance on all of these things as they come up. Now, the rest of the thing, when we go in and we actually file a case within juvenile court, what happens is that we file a petition, and in that petition, there's an order to appear. Sometimes a minor is arrested, sometimes not. But in any event, they get the order to appear, and the family gets an affidavit of request for an attorney. And so they can fill that out, financial obligation, to see what their financial status is if they want to request an attorney for their child. The child requests an attorney.
Mr. Barron, I'm
Parents
sorry, I probably should have given you a heads up that maybe you only had a couple of minutes. I appreciate the dissertation on the process of the juvenile court process, but this committee's received considerable information regarding the process. I think you can fast forward to substantively your position and your association's position, which I understand. I think I heard you say your association hasn't had an opportunity to take a position on this bill.
Yes, Mr. Chairman. I speak to that on behalf of myself and the general intent of the committee, and frankly, because nobody does. But the bottom line here is, okay, if everybody's assured that the system works, or at least it's there, the bottom line is to make the offender and his family not responsible for the cost of his what he's offended. And so this amounts to a cost shift to the county and to the state to bear the cost of what's going on here, and the minor and his family doesn't have to pay for anything. And the other thing is that it seems to me that what this bill does is it eliminates financial obligations that could be paid for by the families through private health insurance, as often happens in these kind of cases. And that shifts that cost over to the state of Wyoming in that particular matter. So in these times, I can't imagine why the state would want to do that. The other thing is this in the statutory language there, where it says on page 5, lines 7 through 13, This eliminates any penalty whatsoever for obtaining a traffic citation. So a kid's driving his motorcycle 120 miles an hour down the highway, which they do, there is nothing that can happen to that child for doing so. This legislature took away jail time for traffic, many of the traffic citations. And this law right here, because it starts off, it says regardless of the court of jurisdictions determines to be appropriate, those fines go away. And so there's that. With regard to the tobacco citations, if there is no fines, the net effect is nobody's going to arrest a minor for something when there's no penalty for it. And you basically will have created that. The other effect that this law will have is because there aren't any financial obligations here, and I'm not so sure, I haven't figured out exactly if you guys, this bill will get rid of the restitution requirement, since that's a financial obligation that for victims who have financial obligations against them, where victims are owed restitution on that. And I don't know if it fines, costs, surcharges, that sort of thing there. And that needs to be addressed to make clear that victims can still be made whole in this thing. There's the other thing here is that community service, frankly, that is not that big of an option anymore. In order for somebody to do community service, you have somebody on the other end that's willing to supervise that. And what DFS does in most cases is they tell the minor, okay, you need to go get some community service. And then they leave it up to the minor to go figure it out and do that. And in my experience for the past 30 plus years with community service, we used to do a lot more of it than we do today because nobody is willing to take that risk and that obligation to supervise somebody, some kid to do something. So community service really isn't that big of an option as it once used to be. And DFS, we have one person up there. They really don't have the time to go run around and get this all set up with private people to do that community service, or even government agencies that will do that. But this is a huge cost shift, this bill. It shifts costs back to the state where money is available through private insurance and other things.
What is,
it gets rid of all the obligations.
sorry,
on
Mr.
folks.
Barron, what is the cost shift to the state?
Okay, the cost shift to the state will be the attorney's fees in one case. In our county, we do collect, and I've been doing this since 1986. We do collect court-appointed attorney's fees from the family members. And in our case, the reimbursement for 2019 was $8,047. And then in public defender fees, that was about $6,500. Victims compensation was $10,000. Restitution was $22,000. And this includes everybody, not just minors in this particular case. But the court-appointed attorney.
Oh, I see. So that's not just minors, that's everyone. Because
No,
I have the statewide data, Mr. Barron, in front of me. For example, for the public defender's fees, it equates to it looks like a potential total of $42,750 in lost revenue annually for the entire state. So I'm going to guess that Crook County is probably maybe a couple thousand out of that. Would you say that's probably accurate?
I would think that to be the case, probably. I don't know that. I do know this on a county level, the cost shift for 2018, we pay out attorney's fees for the parents' attorneys in these cases here. And now if you eliminate this law, then the county's going to have to pick up that tab. And I'd have to look at our budget, but I think our attorney's fees budget's in the nature of about $20,000 a year of what we have to pay for parents, attorneys in the matter. And we collected about $8,000 in 19 and about $4,600 in 2020.
Yeah,
The way that works is the judge issues an order
Mr.
for about
Barron,
25 bucks a
excuse
month.
me, Mr. Barron, excuse me. I think what would be more helpful is if you want to go ahead and put that data together and email the committee. So, I appreciate anecdotal testimony, but I appreciate more factual data. So if you, rather than saying that this is a cost share to the county, what would be more helpful to me and to this committee is if you gave us the dollar figure that you believe is an impact. And the same, you can break down those categories as you want, but that would be more helpful than just speaking in generalities. And then I think the same is true, if you're going to give us the data for all public defender fees, for example, this only deals with juveniles. So if you have a way to break that out, I think that's more helpful. Because I've got the statewide data, so I know that. I know it's going to vary considerable from county to county. So in order for us to understand how that impacts your county, if you find a way to break that number out, for example, to your county, that's more helpful. But we have the data for the statewide impact, so we're fully aware of the dollar figures that are at play for all the various categories that you referenced. Does that make sense on what we need from you?
Yes, Mr. Chairman. Has the Wyoming County Commissioners Association responded with any of that data since it's the one coming out of their checkbook?
I have not received anything from the County Commissioners Association, but maybe we'll get some testimony from them.
Okay, Mr. Chairman, I think that would be more appropriate for them since they're the ones that are paying for that, and I will reach out to them to do that. My concern is that if you get rid of fines for traffic citations where there's no other penalty on that, you've basically eliminated criminal prosecution of minors for bondable traffic citations where there is no jail offense.
Thank you. Questions for Mr. Barron?
Mr. Chairman?
The last thing I'll say, Mr. Barron, that might be helpful, and I don't know how soon you can get your, because this, I don't think you're new to the legislative process, but for your association to take a position on the bill, it would not be, bills they come fast, they come quick. We have a short session. I hear all the time from your association on its position on a bill. Maybe, if you're concerned about that, because you did reference that early in your testimony, I think if you could, you poll your members and you can always send us an email. Obviously, I know you're not going to get that today, but if this bill moves forward through the legislative process, I'm sure it would be helpful for the senators to know the actual position of your association. And I would love to hear it at some point too.
Mr. Chairman?
Yes.
This is Corin from DFS again, and we do have numbers and figures on child support, if that would be helpful for the committee.
Yes, I am curious about the child support numbers because that's the one number I don't have.
Mr. Chairman, in state fiscal year 20, we gathered $414,000 in child support on probation cases. That was 228 cases. In state fiscal year 19, we collected $347,000 on probation cases for 237 cases. So we're looking at about $750,000 every 2 years, a biennium or so.
I'm sorry, what was that per biennium?
About $750,000.
Where does that go?
Mr. Chairman, that offsets the cost of placement for the youth. So if a child comes into care and is placed, we refer the case over to district court for a child support action. The child support action then moves forward. It's separate than the juvenile court action. And they go through the regular child support process there. And instead of a payment to the custodial parent, the payment's made to the state. And we deposit that back into our budget to offset the cost. It is part of our budgeted revenue.
So what happens to your budget without this revenue stream?
In effect, it's reducing our budget by about $750,000
And,
annual budget.
okay, and what will you use to make up that difference?
Mr. Chairman, we're making reductions in that budget in other places. We will not be able to replace it.
So have you already made a 10%, or what is the reduction already proposed in the existing budget for that?
So in step 2, we already reduced the budget by, oh, now you're taxing me and I can pull those numbers up in a
You weren't
minute.
ready
But,
for appropriations today.
sorry,
You weren't ready for appropriations.
it's one committee hearing at a time. But we are looking at a 6% reduction in our fees or our rates to congregate care providers, which provide residential treatment center care and group home care. So they will in effect be facing a reduction in the rates. And so this will be just an additional reduction.
So what happens to the juveniles then without this funding to your program?
Well, Mr. Chairman, we'll just have to do our best to manage. Our concern overall with all the reductions that we're facing is that at some point we're going to have to come back to the legislature and just have another discussion. We're doing our best to look at every placement, but those placements are made by the courts. We're trying to reinforce what we're doing in the community side, but we've made some reductions in the community juvenile services boards. So it is a reduction, and I have my information now about our budget reductions if you'd like to ask me questions.
No, I think I understand where you're at with the existing reductions and then what this would do. So I appreciate that. Representative Provenza.
Thank you, Mr. Chairman. Do you have any understanding of how much it costs to collect that money? That $750,000? Thank you.
Corin.
Mr. Chairman, Representative Provenza, we could certainly find that out. It's part of the larger child support program. And so we could maybe do a percentage allocation for how much it costs. But that program is a federal program and managed or funded in large part the administration of the program through federal dollars. And in every community, we have child support offices who then manage those cases. So the cost of collecting is a little bit different than the actual cost of what we collect. Administration versus what we collect.
Follow up, Representative Provenza.
No, thank you.
Committee, further questions for Department of Family Services? No? All right. Well, stick around because as it appears that you get brought into the conversation very easily. All right, public testimony. I think that's my public testimony in the virtual world. Clarissa, do we have any other hands out there?
Mr. Chairman, you are correct. I do not have anyone else on Zoom.
Aha, okay. How about in the room? Ms. Sheen. And others. All right.
I'm Donna Sheen. I am the director of the Wyoming Children's Law Center. And with me are two of our interns this year. I'll allow them to introduce themselves.
Hello, committee members. My name is Shaylee Stone, and I live in Laramie. And I am a MSW social work practicum student at the Wyoming Children's Law Center.
Turn it to green.
Mr. Chairman, members of the Judiciary Committee, my name is Rob Piper. I'm a student attorney with the Wyoming Children's Law Center. I'm a Juris Doctor candidate this year, and this will make my 18th year serving as a peace officer.
Mr. Chairman, members of the committee, this bill is a small step towards reforming part of Wyoming's very unfair and harmful juvenile justice system. I want to start by just reiterating what Mr. Barron had talked about our system being one of concurrent jurisdiction, where children, we aren't like most states. We've created a system where there's concurrent jurisdiction for juveniles, which means they can either be charged as an adult in one of our lower adult court systems, or they can be charged in juvenile court. So part of what we believe is important about this bill is the fact that it tries to help make more uniform some of the consequences that youth and families can face regardless of which system they're prosecuted in. I provided you with some other information, a 2004 report, for example, that explains that in far more detail. So I won't take up your time now, but I'm happy to answer questions about that. But we know in 2004, at least, the vast majority of children were being charged in adult courts where their crimes are a matter of public record and they're subjected to essentially the same consequences as any adult who would be charged. I do want to give credit over the years, prosecutors in the state have worked very hard to try and address this disparity, and many counties have created diversion programs, and the vast majority of children who don't go to juvenile court go through a diversion program instead, which does not impose any fines or fees, but rather usually has consequences that are going to help teach the child and correct that behavior in an effective way. And so we definitely want to promote and hope that this bill will help encourage that. Now, one of the reasons it will encourage it is because not every county does maintain a good diversion program. And so some counties still do process children and collect the fines and fees off of those children. And so what this bill can do is make that more uniform and nudge those counties that haven't developed diversion programs to do that instead. In short, I want to just reiterate this bill essentially does three things. Two of them are in the juvenile court. It eliminates the allocation or the requirement that parents pay an attorney fee for their child if they're appointed an attorney in a juvenile court proceeding. Has no impact on adult court processes because that would have been far more complicated, I think. So it eliminates that, and as Chairman Olson mentioned, we were able to determine that it has at most about 45,000 in effect. It also eliminates the requirement that parents be ordered to pay child support if their child's been removed from their home for a delinquency or a CHINS proceeding only, not for abuse and neglect cases. So that's a separate issue and it isn't contained in this bill. I want to pause now because our students are going to be telling you a little bit about three families that asked us to tell a little bit about their story, and I'll let Shaylee begin.
Sorry, one second. I have a question from Representative Washit, and then I'd love to hear your story.
Thank you, Mr. Chairman. Ms. Sheen, these diversion programs, when an individual is in the diversion program and fails to do those productive sorts of things, what is the consequence for failure to engage in a diversion program?
Mr. Chairman, Representative Washit, thank you for that question. I think there is a number of things that the court is able to do and would still be able to do. So in a diversion program, you're not taken to court. So obviously the first thing is you can always end up having your diversion taken away and you would be put back into a court process where perhaps a judge would order community service. But most diversion programs, if they're run well, we'll take a look at the reasons why that juvenile isn't. And are they resistant, or is it a matter of just not being able to do something that was expected? So in short, I hope that answered your question. question.
Thank you, Mr. Chairman. Just a quick follow-up. And so the judge orders the young person who was resistant to diversion to do community service, and the juvenile continues to be resistant and doesn't do the community service. Now what consequences available under this bill for the judge?
So, Mr. Chairman, I think it would depend on the court, but obviously in an adult court, courts have the ability to arrest and detain anyone who is failing to follow the court's order. You may note that in the bill, there was a provision that removed children from the contempt. It's my belief, and I can double check on that, but the contempt proceeding in this particular provision on page 4, lines 6 and 7, removing that is simply to remove the ability to consider it a delinquent act if a juvenile, for example, smokes, and well, smoking may be a bad example, but any offense that wouldn't be a crime if committed by an adult is called a status offense. And what this provision is removing is the ability to bump up a status offense to be a delinquent offense, because that then allows the detention of a youth. And one of the federal mandates in our system is that we do not detain children who have not committed a criminal act, but have only committed a status offense, which means an offense that wouldn't be an offense if you were an adult. The reason for that is because we know that those are very detrimental to children. They actually increase recidivism to be treating children in that way. And so I think that's the only reason that that's removed, but certainly if they were in the adult court, there is still that ability, inherent ability of the judge to use their contempt and sentence accordingly.
All right. Please proceed with sharing the stories.
Thank you, Chairman Olson. The following statement was given by a father in Cheyenne. A few months after my 16-year-old son was placed at the boys' school in Moreland, my family received a letter stating that we owed $750 in arrear payments for my son's placement in the facility. At the same time, the state began to intercept half of a child support payment that we were receiving for our younger child every month to be used for our son's placement at the boys' school. We were also then informed that we would owe an additional $190 each month to the boys' school. We had been struggling financially before, and on top of all of the money that we now owed and the loss of the child support, we were having to buy cheap groceries and struggling to pay our water and electric bill, had to turn off our cable and internet, and I had to get a second job. I understand that it costs money to take care of someone, to feed them and clothe them, but just because one of our kids got in trouble doesn't mean that we don't have other kids to take care of. We were struggling to pay for groceries, water, and power. It's not fair to the family to have to bear that burden. Thank you.
Mr. Chairman, members of the Judiciary Committee, I have two stories to share from Children's Law Center clients. The first client tells us, my son had a mental health crisis. I called police to help us to keep him safe and to find help. I thought maybe they'd take him to the hospital. Instead, he was arrested and charged with a delinquency. Child support diverted the support I was getting from his father and also ordered me to pay more child support to the state while he was in placement. They also put my child on Medicaid, even though I have insurance on him. Then they charged my insurance for placement in addition to taking child support from me. The placement was out of network, so I had to pay my deductible for the year. Even after he came home, they kept taking my child support for several months before I was finally able to get it stopped. The state never returned the money they should not have taken for the months after he was home. Both placements traumatized my son. It wasted taxpayer dollars. The second is also from a CLC client. My son, who has autism, was having an emotional meltdown in a public place. He was arrested and placed in detention for several days, and the court ordered me to hire him a private attorney because we made too much for him to qualify for a public defender. He was not allowed to waive his right to an attorney. We had to take the money from our retirement fund. The charges were finally dropped after the attorney was able to show that he was not responsible for his behavior due to his disability, but it cost us nearly $5,000 in attorney fees.
So, Mr. Chairman, those are the changes that would be part of the juvenile court portion of this. The third part of this bill will eliminate the ability of the adult courts to charge the normal fines and fees that are related if you're treating the youth as an adult. And the reason for that is frankly, because they shouldn't be in adult court, honestly, in the first place. But if they are an adult court, we do want to encourage that the courts, the prosecutors are looking at developing a different approach to dealing with that youth's offense. We're certainly not saying that they shouldn't be held accountable. They should. But most of the time, children don't have employment. They don't have the ability to pay that fine. It's put on parents who often end up paying the fine, and that doesn't teach a child, a lesson. But when you look at those families who can't afford it anyway, it ends up really being an unfair tax on the poor. And part of what the materials I sent you also helped explain why fines and fees generally are not an effective criminal justice response, and why we really need to be thinking differently if we want our criminal justice system to work better and be more reform oriented. It would be much more helpful if we eliminate the fines and fees and begin looking at targeting the actual types of things that will work and reduce recidivism. I would also want to just real briefly say that it does not eliminate the court's ability to order restitution at all. And so certainly if a kid, does property damage to a building or something like that, the court can absolutely still order the child to pay that restitution. In terms of the child support, part of what, I understand you're in a very difficult year and that any kind of financial cuts are enormous. And so part of what I would encourage you to look at, though, is that a far more effective way of managing the problem that's created in the Department of Family Services budget is to limit the court's ability to take these children out of the home in the first place. You heard about 2 examples of children with mental health issues that were not helped by that detention, and in fact were likely made worse. If we were more careful in defining when a judge should remove a child from a parent's home and exactly where they should be and for how long, we could save far more money. And so I would encourage you, if this is a concern, for us to take a look at that end instead, because placements cost millions of dollars. So in the overall scheme of things, it isn't a large percentage of the overall placement budget that would be lost. And also just remind you that diversion programs do vary. And from what we could understand, most of the reimbursements do not actually go back to counties where they can utilize that money that's collected. It's often placed in, depending in circuit court, I think it goes back to the state. They may reallocate some of it, but I wasn't able to determine that.
Vice Chairman Washington.
Thank you, Mr. Chairman. Machine, how many counties have diversion programs and which counties do not have diversion programs?
Mr. Chairman, that's Representative Washut. I'm not really able to answer that question. I can tell you that there is a statute called the Community Juvenile Service Board statute, and it encourages counties, and the Department of Family Services gives small amount of monies to create incentives for children to remain in the community. There are 15 counties, last I knew, who participated in that and accepted money. Many of those use them to fund diversion programs, but to my knowledge, we don't have any statewide method of determining how many counties use diversion programs.
Machine, I think you hit the nail on the head when you talk about our justice system. And at the end of the day, does the fine do something to change the juvenile's life so that they do not re-enter the system? That should be the object of our justice system, to divert and end repeat offenders, period. Not to punish, not to, and so when I mean, punishment's probably part of deterrence, I get that. But if that should be one of the goals, but probably lower on the list. If we really are to save state dollars, that's what's fascinating about this conversation is I'm listening and I'm hearing about state budgets and county budgets. But the reality is that if we can keep the juvenile out of the system, that's what's going to actually impact the budget. And so I think the diversion programs are important for that respect. But what I'm hearing from the fine is that the majority of the fines are paid for by parents. And so I'm not sure how that changes the behavior of a youth.
Mr. Chairman, I completely agree with you. And I think that even though Wyoming doesn't have any data, there's certainly plenty of national data that shows that as well. And that's one of the reasons I think it's important for this bill to pass and for us to eliminate those fines and fees assessed on juveniles.
Representative Oakley.
Thank you, Mr. Chairman. Good morning, Ms. Sheen. I was interested in some of the numbers, I guess, given by DFS, and it was $750,000 that was brought in under the child support program, which I was struck by. My question would be if that is no longer assessed, because that was actual dollars brought in, if it becomes less self-funded, aren't you, or would you be concerned about the decline in the availability and the functionality of that program, which is separate from the fines and fees? Because as we've talked about, with a fiscal crunch or crisis, or without that being replaced, the state might not replace it, in which case, I guess my concern is, again, the degradation of the programs that are currently in existence without that funding.
Mr. Chairman, Representative Oakley, I think first that it would require the department and others, I think, to take a look at how the decision is made in order to even take that child from the home, where they're placed, and why the state needs to charge the parent any child support. And I would urge this committee to do that. In fact, I would urge the committee as an interim topic to really study our juvenile justice system, because this is only one of many issues that I think need attention in Wyoming for juvenile justice. I do think that again, the child support that is collected from parents, I don't think has any direct impact on the kinds of services. I do think that we have a lot of placement options for children, some of them much better than others. And I think that's another issue that the court or the judiciary should look at, or excuse me, the legislature should look at. And the cost of them are different. I think as we look at these budget cuts, I think you need to ask yourself, why is it that we do need to maintain a boys' school and a girls' school? Right now, take a look at what they cost versus how many children go there versus the cost of a placement. All of those things are very important, and I think very timely given the budget that we're facing.
Representative Provenza.
Thank you, Mr. Chairman, and thank you, Ms. Sheen, for your information on this bill. Are you aware of other states that have eliminated their juvenile fines and fees, and kind of what happened there? I mean, I know for adults, we see that states that end up spending more, about 17 cents more per dollar to collect those fines and fees. And so I'm wondering if you know of other states that have done this, what has been the consequence or maybe the benefit of eliminating those juvenile fines and fees?
Mr. Chairman, Representative Provenza, thank you for that question. And yes, I have provided, I believe, the committee with quite a bit of materials on that. But in essence, most states find that there's very little overall cost loss because it costs a lot to maintain these, maintain the records on these, to collect them. If you think about it, if someone doesn't pay the fine or fee, let's go back to that tobacco offense, and he's got a $25 charge and he doesn't pay it. What does it cost to then arrest that juvenile, put them in detention or jail for a day, and then have the hearing, have the court's time for that hearing, those kinds of things. And that's where, when states really took a look at the overall system and the impact, they found that it really was fairly neutral. What they gave up in the bureaucracy of the process saved them time and money, obviously, in budgets. And in most cases, it was very little impact overall in terms of income versus the expenses that they were able to save. And I'm happy to provide that if all of the members did not get that, but.
I think everybody has that. Does everyone have the data? Further questions? Machine? We appreciate your testimony. Appreciate the interns coming in to testify. I mean, it's a little bit different than testifying in court, but I guess it's kind of similar in a lot of ways. So good practice, huh?
Thank you, Mr. Chairman.
All right. Good job, guys. Appreciate you.
Mr. Chairman,
Yes.
Joseph Barron has raised his hand again on Zoom.
Okay. We will circle through remainder of public testimony, and then we'll come back to Mr. Barron. Any other public testimony?
Mr. Chairman, members of the committee, Lee Livingston, Park County Commissioner, representing Wyoming County Commissioners Association. Just want to give you a real quick brief that due to the craziness of this session and how fast things are moving, we have not had a chance to review this bill. We appreciate the attorneys bringing it to our attention. Needless to say, if it would have a financial impact to the counties, we'd definitely be looking at it. And we will be reviewing this bill today. The way our association works, we review all bills of interest. They need to reach a 70% threshold in the meeting in order for us to support or oppose. But this bill will definitely be being reviewed later today, and we'll be able to provide input after that. If I'll stand for any questions, not sure I can answer any though. Thank you.
No, we appreciate that, Commissioner Livingston. And can you email that out to us from the association? Once
Yes,
you
Mr. Chairman, we
take a
will.
position on it. I appreciate, I mean, it is a short session and a lot of bills. So
We're tracking over 100 bills right now. So it's this one, and this one came on quick.
I appreciate that. I just wish I could say I haven't had time to read the bill, so I don't have a position on it, but I have to take a position on all these bills.
Thank you, Mr. Chairman, members of the committee.
Thank you, Commissioner. Mr. Odekoven. You hang out in this room so much, you just become a fixture, and then I'm sorry I looked over you for a second there.
Thank you, Mr. Chairman. Byron Odekoven, the Executive Director for the Wyoming Sheriffs and Chiefs, rising kind of with some questions, if you will, on the bill and kind of the direction it may take us. So first and foremost, coming from the law enforcement position, it is a desire and a welcome nature to have early intervention, especially dealing with youth. The earlier in the process that we can intervene in that activity, whether it's status criminal or otherwise, so to speak, the more likely we are to modify that behavior. So again, we don't have recidivism, or we don't have a repeat offender, or they don't graduate up the compendium to a more serious offense, which then increase our costs significantly. So early intervention being one of our first thoughts as we review the bill, we look at what does this bill accomplish in modifying behavior and providing that early intervention. And that's where it becomes questionable in my mind as we kind of look at it. So if an officer observes that activity and takes a level of action that results in the youth going before the judge, what could be the consequences? So at first blush, we have the point of single entry, where the county attorney looks and determines whether the case will proceed or not, whether we then divert, if you will, to something else outside the diversion programs. So whether the county attorney chooses to divert that youth off to, we've already talked about community service. That's getting harder to do, Mr. Chairman. The liability, the insurance, the type of youth that are involved, the type of activities that there are, aren't out there necessarily to provide that opportunity. So that early intervention moment is being lost a little bit. In terms of modifying behavior, again, it's that consequence. So that youthful offense, whatever it is, has a consequence of having to go do this, whatever that this turns out to be. And if we eliminate that, then we're left with the court going, okay, if I can't do a fine and I can't do a fee and I can't do anything, what are we actually accomplishing? And is the youth going to learn, as long as I do it, I get a ticket, nothing happens? I'm not sure why I shouldn't do it again. So, Mr. Chairman, with all due respect to when it comes to fines and fees, I would hope that at least in the fine world, that it have some impact on the youth and maybe the family to have a family discussion of the activity of that child for future reference, so that we don't end up with things going forward. In terms of fees, if you will, very concerning as we look at the state budget reductions and the state cost shift, if you will. We mentioned diversion programs. Those are funded locally for the most part, with some seed money from the community justice dollars from the state. We're already on notice. Those dollars do go away next year, period, unless the legislature intercedes and puts money in. So in some forms, in some communities are very concerned with the youth home, if you will, where some of those placements take place, or the diversion programs, or the ability for other programs to operate within that community justice or community youth. I apologize, I'm getting the acronym in my little brain mixed up, but the dollars devoted to youth services from the state, as I said, will go away. So I think there's lots of ramifications to this bill outside of what may be just proposed this morning, that I would suggest that if this is of interest, it may be better to study this discussion and take in the totality of the situation rather than merely react to a nice idea of removing fines and fees. So I think as the county attorney from Crook County mentioned, what consequence do we have for the youth who does that traffic offense to the nth degree to convince him maybe he shouldn't do that anymore if we eliminate all fines, fees, and options? So, Mr. Chairman, raising more questions and concerns, but suggesting again that if it is of interest, you may want to look at this in the bigger picture, especially in light of the budget cuts, rather than merely react to the bill today. Mr. Chairman.
Questions for Mr. Odakoven? All right. Thank you, Mr. Odakoven. Additional testimony from the room. Oh, we're nearing it. Okay. Clarissa, will you let Mr. Barron in?
Yes, Mr. Chairman, and just to let you know, Chelsea McMichael has also raised her hand on Zoom.
Oh, okay. Let's go ahead and let her in too. Because I thought she was testifying on a different bill, but if she wants to testify on this bill. Clarissa, are you gonna let her? You can let her in right now as well.
Mr. Chairman, she is in the room.
Oh, okay. We're just
Sorry about that. I was on mute. I just have maybe like a 5-minute thing. So I did work at a.
Miss McMichael, hold on. Sorry.
Sorry, go ahead.
So, I'm gonna give you less than 1 minute.
Okay, that's fine.
Just because we're trying to wrap it up. But please introduce yourself first, and then just try to distill that as best as you can into a minute.
Yes, sir. So my name is Chelsea McMichael. I actually worked at a peer specialist program in Utah. On December 14th, the state legislature was looking at cutting back the wraparound program. This is the kind of program that would be helping these at-risk youth. And I would just hope that we could take another look at that. And that's all I have to say. Thank you.
Well, that was even shorter than 1 minute. You did really good. Thank you.
You're very welcome.
See that? There's something about the human brain, and it probably only pays attention for like 30 seconds. So even though we want to say a lot when we say it for 5 minutes, I think as much as we want to pay attention and try, the human brain doesn't do so well for that long. But thank you so much.
You're very
Mr.
welcome.
Barron, I generally wouldn't allow a second bite at the apple, but if you promise to try not to repeat anything, and hopefully maybe you're coming back to answer some of our questions, and if you can do that in under a minute, that'd be perfect.
Thank you, Mr. Chairman. Yes, I heard a few things there and I just wanted to address them. First of all, with regard to the $750,000 collected by Child Support Authority, that money goes to DFS. There is nothing that eliminates. What will happen is courts, because they're not looking at a checkbook, courts will still be ordering placements. DFS and the state will have to come up with the money. And there's nothing that restricts the courts from placement options that there are. As far as the fines go, you heard anecdotal evidence about how the parents pay all these fines. My experience is quite the opposite of that. Children pay the fines. I talk to parents every day about this stuff. Parents pay, and if they do pay, they impose the consequences on their children to do that. So fines do have a course, and children do pay one way or the other to do that. And in my experience, a lot of kids do have jobs, and most kids do pay these things. And it's the parents that are the ones that are saying, hey, look, you need to go take the Alive at 25 program that the attorney offered you, because then our insurance rates don't rise. And so they're paying this all the time. The other thing is, one of the representatives there asked and said, what happens if you can't impose any consequences on this? Well, if you have a fine only offense, that's a status offense by definition under the Juvenile Court Act. So essentially, you can't file a juvenile action for those fines and tickets that don't have jailable offenses, like speeding tickets and that sort of thing, careless driving. And so what will happen there is that there will be no consequences in juvenile court on that. And the other thing that with diversion programs that was addressed, the state used to give out 25,000. I think it went down to 22,500 a year through the DFS budget. That was cut in the budget cuts here this year. So my guess is we're actually, in our case, looking for money to pay for that juvenile diversion program. And frankly, we're not aware of where it exists. So we will push back on the state to operate that diversion program through DFS.
Thank you for that additional information. Questions for Mr. Barron? No? All right. Thank you, Mr. Barron.
Thank you.
All right. Seeing no additional public, do I have anyone else out there, Clarissa? Maybe I should ask.
Mr. Chairman, I do not have anyone else on Zoom.
All right. And nobody else in the room wants to testify, or do you? All right. Seeing no further public testimony, I'll close public testimony committee. What is your pleasure?
Move the bill, Mr. Chairman.
Moved by Representative Zwanitzer, seconded by Representative Provenza. Discussion on the bill. Representative Crago, or Representative Zwanitzer, sorry.
Thank you, Mr. Chairman. Just want to speak in support of this bill. I had an instance in my family last summer where my juvenile decided to have an attack, panic attack, and lost his composure and punched me in the face pretty hard on the front porch. So police were obviously called. And at that point, they told me since I was a domestic violence victim and I could not decline to press charges, so they charged my son with domestic violence. And then the court told me I had to pay all of the fines and charges for my son because he was a minor, even though I was also the victim. But that I could go through the Victims Restitution Fund to help fund my, it was the weirdest, most complicated and dumb thing that I've had to experience in a while. So I understand that there are punishments for kids, and when they screw up, they should have something. But I also understand there are families that take that seriously, and there are other families of minors who don't, and it just makes it worse on everyone. So I think the bill's a good idea. The child support stuff does give me pause, but the overall intent of the bill, I would encourage your support.
Representative Craigo? That silenced Representative Craigo. Wow. Vice Chairman Washit.
Thank you, Mr. Chairman. I think we heard from at least 2, maybe 3 witnesses that this would make a good interim topic, and I concur with that. I think we need a more holistic approach to take a look at all of this. The $750,000 does give me pause, significant pause. The lack of sanction and consequence gives me pause. So I think the bill is well intended and perhaps needed, but I think we really need to make a deeper dive and get a better understanding of the whole juvenile justice system and look at the financial aspects as well as the practical aspects of the juvenile justice system in Wyoming. And so I'll be a no vote today, but I sure hope we can consider it as an interim topic.
Thank you. Representative Oakley.
Thank you, Mr. Chairman. Representative Washut just said a lot of what I was going to say, so I won't restate it, but I do think that we haven't necessarily looked at what could be the fiscal impact to counties. If there's a switch, it seems like a lot, as the state budget gets tight, it gets to be what could be the equivalent of unfunded mandates, if you will, to the counties. And I think we need to discuss that with the counties and really flesh that out. So I'm with Mr. Washut, even though there's certainly aspects of this that I'm interested in and willing to talk about and look at. I don't think it's ready at this time. So I will be a no vote today.
If we just let locals tax themselves, then we wouldn't have to worry about these cost share arguments anymore. The cities can pay for what they have on their plate, and we pay for what's on our plate. Representative Provenza.
Thank you, Mr. Chairman, and to members of this committee. I would urge you to put this bill forward. I understand that we are on a fiscal cliff and we are in dark times. But there are people who are in dark times right now because they, as we heard from the stories from folks today, their wallets are impacted to the point that they're having a hard time feeding their families. We also have the cost of juveniles' lives, where they're going to end up because of an over punitive system that doesn't rehabilitate folks. And so our goal for the criminal justice system should be to rehabilitate, make sure that folks aren't at higher likelihood for recidivism and not raise fines and fees. So I think there's research out there, and I'd be more than willing to talk about that with members of this committee and the body as a whole. I think we need to move forward on this because I think people are hurting in this area. And I don't think that the cost is going to be nearly as much, just given that we see how much it ends up cost to collect those things, to collect these fines and fees. So I would urge you to vote this bill forward. Thank you.
Committee, further discussion? I'll just briefly say that I'm on in favor of this bill. I don't have as much legislative experience as Representatives Wanser to see, how budgets over time, county budgets over time, et cetera, are impacted. But what I will say is that this bill is a really good example of a couple of things. And one is, even though we don't have Wyoming data on recidivism, I think that if anyone spent any time looking at any national data, it would be clear to them that fines and fees to juveniles do not impact holistically or largely the return rate as you would hope it would. So this argument that we need to have accountability and responsibility is true. I agree. But when the system's broken, you don't keep arguing the same thing over and over and over again. I think I do agree with Vice Chairman Washut that and others that maybe a complete look at the juvenile system, because we really don't have a statewide juvenile system in Wyoming, is absolutely something that we should look at. I would love to spend an interim doing that. That doesn't mean that this bill shouldn't go forward. You could say that about every single issue that the legislature sees. That, well, if we touch one piece of the statute, but what if we just took a grander look at whatever it is? Child support laws, guardianship laws, our criminal code. One could say that we should spend an entire interim looking at our criminal code because it is years and years and years of changing one statute and another. And then we have all kinds of disparities throughout the law because of that. So I think that's true, but it doesn't mean we shouldn't pass this bill forward. In fact, if anything, it would probably, I think what it's done is brought a conversation to the table, which is going to incentivize that legislative process to have a more holistic look at it. Without this, what incentive do we have? I am concerned about the Department of Family Service budget and that cut. But that doesn't mean that this bill shouldn't go forward. There's a budget and there are budget amendments and there are ways to make whole the budget. And then lastly, I just want to say the other thing I think this bill does is really highlight this the state and county issue that we have with funding. And the reality is that these are hard times in Wyoming, and there's going to be cuts and impacts all across the board. And the state's not the only one taking cuts. And the counties are going to have to start to learn to pick up some of the share. And I think in our justice system, this is probably only going to be one of many examples to come where counties are going to have to step up. And that's, I appreciate the reality that those budgets are tight, but that's just a reality of Wyoming. And so I think that this bill helps to highlight that issue and helps to incentivize the greater conversation that we need on that cost share. So for all those reasons, I'm going to be voting in favor of this bill. And I do hope that this committee takes up the interim topic. I'd be one of the first to propose it. And obviously as chairman, have a lot of say on that. So, so with that, I think I heard a question and we can vote on the bill.
Representative Crago,
No.
Representative Larson,
No.
Representative Oakley,
No.
Representative Provenza,
Aye.
Representative Williams,
No.
Vice Chairman Washut,
No.
Representative Yin,
Aye.
Representative Swanitzer, Chairman Olson.
Aye.
Mr. Chairman, there are 4 ayes and 5 noes.
Thank you.
You're welcome.
All right. Next thing we're going to do is consider 2 bills together. We started testimony on HB 140. Representative Wharf, I saw you in the room. Oh, yep, you're still in the room. And now we have HB 212, both dealing with expungement. So what we're going to do is we're going to put them both on the table to move forward. And Representative Wharf, we heard from you. We've heard some, you can please, yeah, absolutely. We've heard some testimony. And so what I'm going to do is allow Representative Provenza to present her bill and provide her testimony. Then at that point, we're going to have both bills on. I'll open the public up to comment and discuss either bill or both bills universally. And but with the caveat that if you've already testified, you know, I think we'll move forward unless your testimony maybe is specific to Representative Provenza's bill, then that might make sense. But I'd prefer not to duplicate testimony. And I will just say to the public, so you kind of got an idea of what's happening here. I've tasked both the sponsors with getting together and working, because the bills address the similar statutes. I tasked them with getting together and trying to work a way to get their bills in sync. Because if they're not, and two bills go out, even if they are in sync and two bills go out, it only takes one body at some point, whether that's a committee or the House or the Senate, to make one change to the provision, and then you get two competing bills. So my absolute preference is to not do that, which is why I'm stacking the bills together. My preference is to come to an agreement on getting the best of each world into the bills, and then getting a bill out. And so I say that to the public because that might help frame some of your testimony on the bills, knowing that there are considerable amendments that are going to be proposed by this committee to both bills, to try to do that, to mirror them to the greatest extent possible. And Representative Provenza may even speak to some of that in her presentation, so that we don't, I say all of that so we don't spend a lot of time discussing a provision that maybe the sponsors have already agreed. We're going to try to pull that out of the bill in order to mirror them a little more. So with that, Representative Provenza, if you'd like to walk us through whatever you'd like to talk about relative to expungement.
Great. Love talking about expungement. Thank you, Mr. Chairman. This bill, I'm not going to go into a ton of detail and as to why I brought it here today, just that we have folks who are struggling to get jobs because they have a criminal record. And they have otherwise rehabilitated themselves. They're doing well. They're, as we heard from Miss McMichael, Chelsea McMichael last week, that she's volunteering, she's doing things in her community, but there's a bar to what she can do and accomplish career-wise, housing-wise, because she has a felony on her record. And it's really important to talk about jobs and housing, because those are the two things that are going to determine whether someone's at a higher likelihood of recidivism or not, whether they're going to end up reoffending. And that's a big deal, because that ends up costing the state more money and then the cost of people's lives. So this bill is a little bit more complicated than the bill that we heard last week, House Bill 140. In this, you'll see in the bill that we talk about, so on page 1, petition for expungement of records of conviction of certain misdemeanors, filing fees, notice, objections, hearing definitions. Basically on page 2, you'll see that what I've done is reduce the years for misdemeanors. So we had an issue with the first bill that came before the committee where we discussed that the waiting period for misdemeanors is currently 5 years, whereas felonies is 10 years. So I've changed on line 7 that misdemeanor waiting period from 5 to 2. Additionally, you'll see throughout this language on line 18 and in other places that we have reduced the fines or the fees to petition the courts. This is just in accordance that it ends up costing the folks oftentimes an attorney they'll get to help get through expungement, and just trying to lower the bar so more people can file for expungement and be more productive members of society. And then in line 23, I also allow for people who have had 2 misdemeanors, and that's only inclusive to the misdemeanors. That's not true for the felonies, but oftentimes people are charged with 2 offenses, not just one. We like to stack things up. Then on page 3, we go into the petition for the felony conviction. So under 7-13-1502, that's where we're considering felonies. And this is where I change it from 10 to 3. And I'll talk with you more about that in a minute, as I have some possible amendments that I think would appease the committee based on conversations from last week. Additionally, another change you'll see on here at the bottom of page 3, line 22, is I allow for an expungement of a felony use or possession of a firearm. This is not, this does not include using a firearm in a crime. So just owning one or being in presence of one, I guess. And then on page 4, line 5, you have, we changed that fine, that fee from $300 to $100. And then we also are reducing the number of days that the process occurs over from 90 to 45 on lines 12 and 16. Then on page 5, again, you see that change. Section 2, and I imagine that the committee is going to want to repeal this section and remove it. This is this basically makes it so that prosecutors can't appeal the court's decision. In that the court made the decision to expunge and now the prosecutor is appealing. They're involved from every step of the way. So I had inserted that because I had assumed that, my thoughts are that you shouldn't have a say over the judge, but I also understand wanting to make sure that we don't expunge people that shouldn't be. So that is, and then it's effective on July 1st. So that's the bill with all of its bells and whistles. I have given the committee before this meeting proposed amendments that you could make. Choose your own adventure. So if you want to say Amendment 1, you can change the title, and that would make this bill more like House Bill 140 of restoring rights, making sure that we are working with folks to get their rights restored after they've been convicted and expunged. Amendment 2, I removed the language that strikes prosecuting attorney appeal process. This is just to make it easier for you to take that out if you so choose. And then we have amending a waiting period that I'm also happy to, what I have here is 3 and 5 years. I will say that the evidence suggests that the recidivism rate drops somewhere between 3 and 5 years. 5 years is the tail end of that. So when I came to this bill for the committee, I thought, well, let's follow the evidence. What does the science say? So I would suggest if you are uncomfortable with the 2 and 3 years to amend that language to 3 and 5. That would still be under the umbrella of what we see as evidence-based. And that's when people are less likely to recidivate. And then on Amendment 3, amending a waiting period, or that was what I just went through, my apologies. And then removing the firearm possession. Quite frankly, I think I overlooked this, but you can't, you would have multiple felonies if you are then convicted of having a felony, being in possession of one. So that doesn't really do anything conceivably. So that should be taken out of the bill. And then the last one I have is removing reduced procedural petition days for review, allowing for more time for the process. I understand that bureaucracy sometimes takes a while, and so we should do our due diligence, and I would be fine with that amendment. I would urge you to keep the fines and fees lowered, just given that this allows for more access so people can get jobs. And that's all I have, Mr. Chairman.
Questions for Representative Provenza on House Bill 212 or the amendment? Representative Oakley.
Thank you, Mr. Chairman. And thank you, Representative Provenza. I've got a question for you in regards to the policy behind it. We hear often the reason for this is people are struggling to get jobs because of having a conviction. How do you respond to the fact or the question for employers that you're taking away their right to do for their decision-making ability based on the fact or the truth that this person in front of them applying for a job with them did in fact commit such a crime, and that it might be relevant to their employment? So a couple examples I can think of is, let's say, possession of prescription drugs. Often, if there's if there were drug seeking behaviors, they go apply at Walgreens or at vets offices is something commonly seen. And then another one I can think of is theft, which is often why it's important to have the conviction to flag employers. And some of these things, we do see a recidivism rate, regardless of if they're caught or convicted. The behavior is something that can be repetitive. So what would be your response to that as far as specifically trying to basically hide the conviction so that they can get a job? But how does that affect the community and the employer?
Yeah, thank you. Sorry, Mr. Chairman. Thank you, and Representative Oakley. I certainly can understand the concern for jobs there. I would say that, when we're talking about somebody who's maybe done something when they're either young or they were at a different point in their lives, do we want to continue to hold a decision they made against them for the rest of their lives so that they can't be reformed? In terms of whether someone's likely to reoffend or not, we see, the 3 to 5 after they've been released. And so at this point now, they've gone through probation, they've done their community service. And I would like to believe that the people of Wyoming believe that these folks can turn things around, and that they shouldn't just, that we shouldn't just keep it to protect that. So I can understand the frustration, but I think that we benefit more from trying to remove that stigma of being an offender and allowing people to get gainful employment in the state of Wyoming. I don't know if that answers your question to the degree that you would like, but I certainly think it's on the employer too to do their due diligence of making sure that this person is who they say they are right now and not who they were maybe 10 years ago.
Or 5.
Or 5 or 3.
Right. We're not getting rid of, we're not just automatically expunging the sentence right. I think your amendment drops it to 5 years for a felony. Is that right?
Yeah.
Representative Oakley.
No further questions.
Oh, okay. Vice Chairman Washit.
Thank you, Mr. Chairman. On page 3, line 22, where you take out the felon in possession of a firearm provision, I just want to hear your rationale again, because we're talking here about someone who's been convicted of a violent felony, who then is found in possession of a firearm after being convicted of a violent felony. So we're not talking about law-abiding gun owners here. We're talking about violent felons. Why is it you want to remove that from the prohibition list?
I mean, I think that in some cases it's that they own a firearm and they're walking around with it. But other times they are around, maybe they are with people who are shooting firearms, and they're otherwise being completely responsible. I mean, my rationale was to just kind of remove some of these things that maybe folks in Wyoming don't agree with, just because I've heard a lot about concerns about Second Amendment rights, things of that nature. Like I said, though, I am fine with taking that out. I think that's completely fair. And I also understand the concerns of people who say that owning or possessing or being near a firearm when you've been ordered not to, you're not following the rules and you are potentially dangerous at that point. So putting that in was probably an overthought.
Representative Worf, would you agree with the logic of removing that provision?
Mr. Chairman, I would. Thank you.
Okay. Representative Yin.
Thank you, Mr. Chairman. So I know we're talking about the timeline after you've completed all the programs, but do you know maybe the average time between the commitment of the felony and the time that someone gets an expungement? Because it's definitely more than 10 years, right? It's whatever their sentence or probation was and whatever completion of programs. So I want to get a feeling for like how big of a difference of time it is between when they can get it expunged and when they commit the felony. Thank you, Mr. Chairman.
Thank you, Mr. Chairman and Representative Yin. I don't have data on that right now in terms of how long someone waits. My understanding is that the wait period is quite a while, particularly if someone doesn't have it, as we heard from people who testified last week, the story of a young man who committed a crime and then was, 15 years or so later, after he had completed his probation and parole, after he had paid his restitution and his victims' fines. So I don't know what the average wait time is. I would suspect that many people don't even try to go for expungement or don't know about it, aren't sure how to go about doing it. The average, just the lay people, this isn't an accessible piece of knowledge that maybe they had. Maybe their defense attorney was busy and didn't tell them you could expunge your record. So I think on average, people don't go for expungement, but when they do, they often wait a long time. I'm sorry, I don't have a better answer for you.
Okay, nearing the third day on expungement discussion. You got a burning question for Representative Provenza, or can we go to public comment?
Well, I just like to speak to Representative Yin's question.
Well, let's save that for our committee discussion. Any other questions for Representative Provenza?
Thank you, Mr. Chairman. I just had a question regarding the proposed amendment to the statute on page 2, the bottom regarding 2 expungements. And so essentially allowing a person to apply for 2 expungements of a misdemeanor. Sort of what's your thought process behind that, and what's the science to back up that change to the statute? Thank you, Mr. Chairman.
Representative Provenza.
Thank you, Mr. Chairman, and thank you, Representative Crago. Oftentimes some of these lower level misdemeanors are things of maybe petty theft or other crimes that are driven by poverty, allowing for them to be able to get better access to employment would be one benefit to that. And that was kind of the genesis of looking at that, is oftentimes people aren't given just, one misdemeanor on an offense, particularly maybe if we plead down from something more serious. I don't have data on hand right now to say that most of the data that looks at reoffending or concern about what happens to someone after they have served their time and gone through the programs that they've been assigned to through the courts is on these more serious offenses, felonies oftentimes. So I don't know that there would be great data, although I certainly would be happy to reach out to the Department of Corrections or local municipalities to see what their thoughts are on that.
All right. Other questions for Representative Provenza? No? All right. Stick around. Oh, Representative Wharf, did you want to say something?
Yes, Mr. Chairman, just a question. I did have a different amendment that was to my bill, and I believe it's been handed out. I didn't know if you wanted me to present that now, or if you want to take public comment first, or.
Is this your amendment?
Yes, sir.
Yeah, you want to explain that to us?
Yes, I can. What you have before you is a simple amendment to House Bill 140. You can see that I've added to the title and misdemeanor. And then what I've done is I've pulled in the provisions of expungement under 713-1501. And you can see that I've made a few changes. We've reduced it from 5 to 1 as we have in House Bill 140. So it would mirror the same waiting period. And I will reiterate it again, because I think it can't be lost by this committee. It is not obligatory at 1 year. It says at least. And I frankly believe it's been stated before that people are going to have a hard time paying the restitution and everything. I think that they're gonna have a hard time satisfying everything, even within a year after they've done their time and everything else. So I still think we're better off to allow the courts to determine that rather than us to set what I would say is an arbitrary and capricious timeline. The last thing it does is it was brought up, Representative Crago brought up the question about what happens if you can only do it once and you're denied. We added an amendment in there that says that you can have an additional expungement, so you can make an additional request. So, and that's both under 713-1502, which addresses the felons, and under the misdemeanor. So it's the same amendment. So with that, Mr. Chairman, that's the amendment that I believe pulls in the similar parts from Representative Provenza's bill, and I would just leave that with the committee. Any questions you have, I'd be more than happy to answer them.
Questions for Representative Worf? Okay, all right, stick around because of the unique nature. I mean, we'd be happy to bring both of you in during, since Representative Forenza would already be in the conversation during working the bill, be happy to bring you in, working the bills.
Okay, thank you, Mr. Chairman.
Yep. All right. Public comment.
Mr. Chairman,
Yes.
both Mr. Barron and Ms. McMichael have raised their hand on Zoom.
Okay, and for Ms. McMichael, we're not repeating testimony, so we took your testimony during our last meeting. So I'm sorry, but if you do have something additional, you can certainly feel free to email it out to the committee, get us any additional information you need, but we did already take your testimony. Mr. Otokoven. Or sorry, yeah, I knew a hand came up right there. Okay. I had you, Ms. Chambers, digitally, but now you're here. Smart move.
Good morning, committee. My name is Kara Chambers. I'm with the Attorney General's office. You'll have to forgive me because I have not seen the amendments. So perhaps a portion of my testimony is moot. We were, of course, flagging the inconsistencies between the bills as far as the timeline. I'm not clear that that's been resolved, but that was something we brought up. And we were also flagging the status of the felony firearm, but so that's back in, meaning it's out of your bill, but back in the law, to be clear. Okay. The only other comment that our agency wanted to make was, while we did provide a formal fiscal note, and it does state that there would not be a fiscal or personal impact to the bill, that is sort of a technicality. It's a true answer because these funds go directly into the general fund. They're not directly appropriated to DCI. However, we wanted to let the committee know that anytime we're increasing a number of expungements, that is going to have an impact on the workload of DCI, which has taken significant hits during this budget crisis. DCI says that on average, they receive 20 to 30 expungement requests a month, and that can take anywhere from 1 to 3 hours. They anticipate with the timeline changing, the gal who provided me her info said, I'm no mathematician, but she thought she would see an influx of around 2,000 plus initially. And that obviously has an impact on productivity and personnel. Beyond that, I believe.
Ms. Chambers.
Yes.
On that figure, was she looking at just felonies or felonies and misdemeanors combined?
We were looking at both bills, Chairman Olson.
Okay, so
we were
2,000.
just sort of, I mean, again, it's a ballpark guess.
Okay.
She said, in fact, her exact statement, Chairman Olson, was, I think it's logical that we at least see a temporary increase because of people that were between the 3 and 10 year period would immediately qualify, so they could all petition the courts at once. If I did my math right, I'm no mathematician, we could immediately see an influx of around 2,100. And with that, I would stand for questions, sir.
I'm no mathematician. That's why I probably became a lawyer.
Amen.
All right. Questions for Ms. Chambers? Representative Provenza?
Thank you, Mr. Chairman. Thank you, Ms. Chambers. Maybe you're not the right person to ask this question, but if we had an increase in folks and with the fines, I mean, or the fees that they have to pay for this, would we see an increase in funding? Because they would have to pay for that, or does that go directly to the county?
Chairman Olson, Representative Presenza. So the money right now goes directly into the general fund, and then is reallocated. So while our agency can't say that this bill directly impacts us, obviously there's less in the corpus that then gets reallocated through the budget process to everybody.
Vice Chairman Washington.
Thank you, Mr. Chairman. Ms. Chambers. If I remember the budget bill correctly, I think DCI lost 11 positions. And do you know how many of those were related to this function of doing the background checks?
Chairman Olson, Representative Washington. I don't have that right at my fingertips. I can provide that later. I do know that the CJIS section has seen a reduction in staff, which was the section that would be dealing with this. It's a criminal justice information system. I apologize. I'm in the government. I use acronyms.
So you'll forward that to us?
I can, Chairman Olson.
if you can
Yeah,
find it.
exactly how many positions the criminal justice information section.
Well, we'll
lost.
probably find out
You
today
probably
or
will.
tomorrow during the Cal explanation of the budget.
Yes.
All right. Other questions for Ms. Chambers? And I think Representative Washington's question is more specifically not on the positions lost, but are any of those positions directly related to the background checks?
Chairman also
Right.
Representative Washington. Yes, the CJIS section lost positions. I believe we handled them through attrition, so it's hard to say if it's directly impacted, but DCI overall has seen a huge reduction in staff in our crime labs. So every time we have bills, I don't want to be a squeaky wheel, but you're going to see this sort of impact that we say, well, look, every time we have another bill that adds another duty, you're compressing an already understaffed agency. And if I may, I did want to acknowledge that I corresponded with Representative Washit about the question to crime victims compensation and restitution refunds with the timelines. I did mention that our experience thus far has been that probation officers and parole office will contact our agency to see if restitution has been satisfied. And that goes into their decision-making. I can't exactly say what the compressed timeline would do to that. And then we do also have a civil remedy to go after refunding our compensation, aka restitution.
Other questions, committee? All right, thank you. Anyone left in the room to testify? Mr. Odekoven, you haven't testified yet. Come on up. You probably see the bewitching hour.
Mr. Chairman, I'm well aware at 3 minutes or less.
All right.
Byron Odekoven, the Executive Director for the Wyoming Sheriffs and Chiefs. Let me mention a couple of points quickly. May not cover everything, but very concerning the time period of cutting back from 10 to 5 to what could be 1, 2, or 3, or some number yet to be determined. More specifically, however, it does create an interesting workload burden of compression of time. We've mentioned compression of time and reduction of fees. In the case of shrinking budgets, not only do we recognize shrinking budgets, but then we also pass on shrinking revenue, which will be of concern. Out of order slightly in the bill, let me also mention the restricted timeline. So this is a shall respond in what was 90 days to now shall respond in 45 days. The reduction in time as you contemplate that 1, 2, 3 year period opens the gate for a number of people to apply. So the workload for the prosecutor and the court has a shall do this in 45 days for an extended number of people that will now be eligible. So do they have the option of doing this? No, they have the option of not prosecuting a theft case. They have no option of proceeding with expungement. So you'll create
Mr.
an interesting
Odekoven,
workload.
I don't think you probably haven't seen the amendment that we've been, or do you have it?
I have not seen the amendment, Mr. Chairman. The amendment may help address that. I'm just pointing
Yeah,
out.
the amendment, it would restore the 90 days and
Ah,
so you might like that one.
thank you, Mr. Chairman. I would. Let me go back in order then. Bottom of page 2, the 2 expungements, and eligible for a third. We mentioned the word petty theft. That is theft up to $1,000. So I can steal from my neighbor $1,000 once, $1,000 twice, and it looks like I may get $1,000 a third time. And currently the statute contemplates that if I have a continuing course of conduct exhibited 3 or more times, the prosecutor may choose to do that as a felony, pointing out the fallacy of my didn't learn from my first offense, didn't learn from my second offense, and now haven't learned from the third offense. Oh, wait, the first offense might go away. So does that make my second offense my first offense? But my second offense goes away. So does that make my third offense my first offense? When do I get my first? Oh, wait, I probably got a 301 in there to boot. So, Mr. Chairman, this allows for some interesting community standards, if you will, as it relates to misdemeanor crime and how the communities to view the seriousness of that misdemeanor crime. So, Mr. Chairman, I think there's a number of issues with the bill and would stand for questions given that there's 30 seconds left rather
Well, I
than
think-
continue.
I think what might be helpful, Mr. Otokoven, is we've got copies of the amendment here. Leave you with a copy of the amendment. You can because you can certainly stew that over. And you mentioned the years, for example. Is it 1? Is it 3? Is it 2? Is it 5? I haven't seen one for 9, but I think that might help you too. So we can it's kind of hard to narrow the discussion when they're just amendments, which I know. I appreciate that difficulty. But we'll give you a copy of this amendment so you can look at it.
Thank you, Mr. Chairman.
Representative Washit.
Thank you, Mr. Chairman. Just a quick question, Mr. Otokoven. Could you speak to law enforcement demands upon the criminal justice information section at DCI aside from expungements? So if we add additional workload to those folks, might that have some ripple effect impact on law enforcement?
Mr. Chairman, it would have a significant impact on law enforcement, and thank you, Representative Washington, for the question. The criminal justice information system comprises the background information as well for all of the cases before the court to provide that background, that records review, firearms, concealed weapons permits, a host of issues that would then grind to a halt if you're dealing with something that they must do in the shell nature. There's a host of other activities that would grind to a halt as they work through the shell portion of what they must do before they get to the optional portion of what you've required by statute. So yes, with the budget reductions that have reduced the number of people and personnel within the agency, as well as your increase in workload significantly, many of those other duties would fall behind, Mr. Chairman.
Okay.
Thank you, Mr. Chairman.
Thank you. Mr. Barron.
Is it my understanding, Mr. Chairman, that I have 3 minutes?
More like 30 seconds, but.
Well,
Because here's where I'm at, Mr. Barron. Here's where I'm at. Maybe this'll help you. Because we're now on day number 2 of expungements. I'm committed to figuring something out with expungements. So, I mean, what if we do this? We got 2 bills. We got 3 different amendments. We got the authors of those bills trying to work together on some consensus here. And it seems like there's only 2 other stakeholders that, well, maybe 3 that could assist with that, right? Mr. Otokoven, I already suspect what Mr. Barron's going to say. So I think Mr. Barron falls into that, and maybe DFS, maybe the Trial Lawyers Association seems eager. So what if we just do this? What if because we've got second reading started 3 minutes ago. What if we do this? We would continue these bills tomorrow during our noon hour. And between now and the noon hour, what if the sponsors, Representative Provenza, Representative Wharf, Trial Lawyers Association, AG, and Mr. Barron, what if we all get together and you can see all these amendments now and you see where we're at? Because I know I've had a conversation with you, Mr. Otakoven, regarding the years. And one of these amendments, at least to my understanding, bumps the years closer to something you're more comfortable with. Maybe it's something Mr. Barron's more comfortable with too. So maybe we could all get together and kind of hone in a little bit on these so that we know. I mean, if you're just opposed to it no matter what, that's okay, obviously, right? But if there's something we can do to figure out the sweet spots, whether it's just a felony or it's the felonies and the misdemeanors, and if it is, what are the years that we're comfortable with? Is it 3 on a misdemeanor and 5 on a felony, for example? And we don't have to, maybe we don't want to touch the other provisions, what I'm hearing from Mr. Otakoven, and the amendment already speaks to some of that. So maybe we could all kind of figure out where we're at and get as close as we can on a consensus for Tuesday. And that might, maybe that will work the best. What do you think about that, Mr. Barron?
Mr. Chairman, I'm glad to have input in that. In that thing, I don't know that it'll be a total consensus, but I'm certainly willing to attend, listen, participate in that kind of format to bring something before the committee on Saturday or Tuesday, just as long as we all have the right to tell you where we're at with that, whatever the recommendations are at that point.
Yeah, absolutely.
Mr. Chairman, how will that work? Will somebody be contacting?
Yeah, I'm going to.
Myself or Mr. Otakoven can contact me about that.
Yep, I'm going to have the sponsors email the amendments, get everyone in that email chain and start trying to figure out if there's some consensus we can reach on some, because I'm hearing there is some consensus on some of this. Ms. Chambers? Oh, okay. All right. Oh, I thought you were raising your hand. Okay. You definitely don't have to. Nobody has to be involved. It's just, I mean, I think we're on to something here from what I'm hearing from the testimony. And if the testimony is just no, then we can just log that right now and move on. But if the testimony is no to this, but maybe to this, then instead of having the maybe testimony, let's get that. That's all I'm saying is let's get that out in front so we can at least talk about the maybes. You know, I've heard a lot about no to 1 year. So let's stop talking about 1 year, but I've heard maybe to 5 years on a felony. So let's talk about that and just trying to narrow this so we can make some progress on the bills. That's all. Representative.
Thank you.
Mr. Chair, I would just ask
you feel what?
I feel like the lone man or
no, I think everyone's dealing with them equally. Yep. Mr. Jennings.
Mr. Chairman, you have several associate agencies in your group. The question is, who is going to represent this felon in that cooperative?
Well, I think that both sponsors are representatives of the felons. I think the Trial Lawyers Association would be such a representative as well. So, okay. All right. Okay. Perfect. That is helpful. I mean, we could work these two bills all week long. I'm okay with that too. There's just lots of other bills that don't get heard if that's what we do, but I'm committed to having some kind of consensus on it. We could just vote on them too, but I think I know the outcome if we vote on them. So, all right. Everyone good? All right. This meeting's adjourned.